can be overturned because they are what's called void judgments. Now, whenever we're doing things administratively, and to address this comment, never expect for them to respond. So whenever you're sending out your letters to these administrative agencies, they're more than likely not going to respond. And if they do respond, it's going to be some vague comment, and they're never going to address everything point by point. And that's okay, because we're trying to get them in default. Now, whenever you get your default, that doesn't mean you stop there. Nothing changes until you enforce it. And here's how you enforce it. So we're going to go over a couple things, and I'm going to talk to you about how to enforce a default judgment or what you need to do moving forward after you get them defaulted. First, we're going to be reading from Corpus Juris Secundum, Volume 49 on judgments. Section 431, to vacate void judgments. A judgment that is void, as opposed to voidable, may generally be attacked at any time, irrespective of the principle of waiver. While there is authority that it must be brought within a reasonable time, it has also been held that such a motion is not governed by the requirement that a motion for relief from judgment be filed within a reasonable time. Delay does not bar a motion to set aside a judgment unless it has been so great that the rights of innocent persons may be prejudicially affected. A definite time limit of a statute or rule of civil procedures governing relief from a judgment does not apply to a void judgment, at least in the absence of exceptional circumstances. So now you got to come up with the argument as to why child support orders are void judgments. And there's many reasons, such as lack of personal jurisdiction, subject matter jurisdiction. There can be constitutional defects and many other reasons as to why child support orders are void judgments. Next, let's read affidavit supporting application. A motion to open or vacate a judgment should be supported under certain circumstances by affidavits concerning the facts on which the applicant relies. So after you default the administrative agency, what you want to do is support the motion to vacate judgment with the affidavit and the default notice. Then you're supposed to have a hearing. The applicant is entitled to a hearing on an application for relief from a judgment if the material submitted by him or her contains allegation of operative facts demonstrating that relief is warranted, and the facts sufficient to support granting relief are challenged by the opposing party. Now, let's go to Volume 60, Motions and Orders. An order taken by default after notice of the motion may be vacated by the court granting it on a showing of a sufficient excuse for the default, and that the movement has a meritorious action or defense. However, in an ordinary case, a defaulting party will not be heard with respect to vacating an order under which much constructive work has been done. Courts have a duty to vacate and expunge void orders. Now, if you want to learn more